I welcome all of you to Company and Partnership Law class. Today we look at the last session of Unit 1, which is Session 6 of Unit 1, and it's on winding up of a partnership. Session objectives. By the end of this session, you should be able to explain the process of winding up of a firm, understand the voluntary winding up, and explain the dissolution after winding up. Now, what is winding up? Winding up simply means the process in which a corporate body ceases to exist. Now, the process in which a corporate body ceases to exist is what you call winding up. That means the company will cease to exist when it goes through that processes. Now, what are the modes of winding up of a firm? We have the composite winding up, that is insolvency against the partners jointly. When the partnership firm is not able to pay its liabilities or settle its obligation as well as the partners themselves, then the partnership firm will be forced to wind up. Also, under an order of the court, on the application by a partner, the court can also make an order for the winding up of the partnership firm. It can also be done by voluntary liquidation by the partners. Sometimes the partnership firm will be incorporated for a certain purpose. Once the purpose is achieved, the partnership can now come to an end. So, with voluntary winding up, the partnership firm or the partners in the partnership firm will voluntarily wind the partnership business. Now, what's happening is that the partnership firm must indicate that within 6 months they will be able to pay the liabilities that they own. If after expiration of the 6 months, whether or not they have fully paid or not, they have to give the registrar notice within 28 days after the expiration. Now, when the notice is given to the registrar for winding up of the partnership firm, the partnership or the registrar will also publish in the Gazette indicating the process of the winding up. Now, what is the effect of winding up? When the winding up process starts, all the activities or all the business carried on by the partnership firm will cease, except those ones that are reasonably incidental or necessary for the winding up of the process. What we mean is that if the process of winding up starts, then the partnership firm cannot operate as a going concern partnership firm. The only activities that the partnership firm will be entitled to carry on is any activities that is in relation to the winding up processes. When the winding up processes starts, the partnership firm still is a body corporate. It only ceases to be a body corporate after dissolution of the partnership firm. Now, dissolution after winding up. We are saying that when the registrar is satisfied that the winding up of the affairs of the firm is complete, if the winding up of the affairs is complete, then what will happen is that unless the undertaking of the firm has been disposed of as a going concern to another partnership firm, and the changes duly, the registrar shall strike the firm of the register and notify the same in the Gazette. So if it is completed, the process is completed, the registrar has to strike the name of the partnership firm in the register of partners and publish same in the Gazette. The firm shall then deem to be dissolved as at the date of publication in the Gazette. So the partnership firm is only said to be dissolve after the registrar has published the notice of the dissolution or the winding up in the Gazette, then the partnership firm will cease to exist. Now, if any property of the firm has not in fact been effectually disposed of in the winding up, it shall be deemed to be vested in the case of voluntary winding up in the partners, and in the case of, in any other case, in the official trustee upon trust to pay out any outstanding liabilities or debt of the partnership firm, and subject thereto for the former partners in accordance with their rights and partnership agreement. What it means is that when there's a loss of property that has been sold, and in the case of voluntary winding up, it will be vested in the partners. However, if it's any other case, then that means compulsory or order from the court, then the property will now be vested into a trustee, and that trustee will ensure that the property has been sold and all the outstanding debts and liabilities of the firm are paid. Now, notwithstanding the dissolution of the firm, the former partner shall remain jointly and severally liable of all the debts and liabilities of the firm, insofar this has not been fully discharged in the winding up of the process or otherwise. What it means is that even though dissolution has taken place, if the firm still owns, the partners will jointly and severally be liable, so the partners will still pay. Now, after going through the dissolution, if you think that the registrar has been biased or has not followed the laid down processes, or you think that the registrar shouldn't have dissolved or published the notice in the Gazette for dissolution, the partners have the right to appeal to the High Court to challenge that decision. If they find favor before the judge, the partnership firm will be restored. By way of summary, in this session, we explained winding up and the process of winding up and the effects of winding up of the firm. We have also studied that voluntary winding up is mostly used by a partnership firm. However, if the partners are not satisfied with the process, they can appeal to the High Court, and if they are successful, the High Court will make an order for the restoration of the name of the partnership firm in the Register of Partners. Thank you for taking your time to go through this Unit 1 from Session 1 up to Session 6. Thank you very much.